Okay, welcome everyone. We'll start our fourth lesson, which is last lesson in term of delivery in the lesson 5. In lesson 5, we'll go through assignment brief. If you have any question, please feel free drop me email on my email address anjum@ukversity.co.uk. So today lesson will go through our learning outcome 4, which is understanding the operation of judicial precedent. So which we'll go through, and if you have any questions, feel free. So before starting our lesson, first of all, we recap what we learned in the previous lesson. Anybody, any thought what we learned? Anything you remember from the previous 3 lessons, please? Anyone? Welcome, everyone. Okay, so what we learned in previous 3 lessons, anything?
The difference between civil and criminal law.
Brilliant. So we learn about
thing.
Yes, well done.
And the court hierarchy,
okay,
structure and hierarchy of courts.
Okay, great. Well done. So we'll learn about the court system hierarchy. Yes. Which one is the bigger court? Which one is the higher court? Okay. What else? We discuss public and private laws. We discuss contract law and criminal law, difference between them. We discuss literal, yes. Golden rules. And today lesson will go through our LO4, which is learning outcome 4. Today lesson will go through understand the operation of judiciary precedent, and then we'll explain the rule of stay decisis and the ratios, and then we'll go through obiter, what is meant by these terminology. As a law student, we should have some basic understanding. So, level 3. So we have 3 assessment criteria. We have 4 assessment criteria. Plus we have 1 extra, which is M1 if you want to work towards. Hello, welcome. Can you hear me?
Yeah, come to 149 Birchfield Road, yeah?
Yes, I can. Yes, I can hear you.
Oh, see them. Bye-bye.
Okay, welcome. So let's play.
Thank you.
So we are going to discuss about LO4 today. We have 4 assessment criteria and 1 further is for merit. So we'll go through all 5. If you have any question, please drop me email. And if you rate yourself, what do you know about judicial precedent? Any question? Anybody? If you rank yourself, where you rank yourself on the scale 1 to 10? Your current knowledge, what do you think?
8.
8. Okay. Anyone else? So rank yourself where you.
Oh, 5 minutes door kholiye.
Okay, yes, please. So where you can rank yourself on the scale 1 to 10?
7.
7. Okay. What about Abby? Where you rate yourself?
Yeah, that's Abby. I just said.
Oh, sorry.
I just said 7.
Sorry, I'm mixing up. Abby, thanks, huh?
Okay.
Who else there? Everyone rate, yes? Okay, let's please. We'll rate yourself, huh? Just a matter of, reflection. Huh? That's always good approach. So first, our learning outcome explain the rule of stay, decisis, and ratios, and obiter, which will go through all these 3. So to understand, I copied the link for you here in the slide. That will help us quickly, because these terminology, I'm not by profession a solicitor, but I normally teach, so I'm just in terms of the teaching perspective. So let's please some of terms I'm just Okay, let's please. So first we see what is meant by decidenti. So what is this meant to you? Have we ever heard these terms? Anyone of us really heard before? Or we know the meaning of them? Okay, so first one is the legal reasoning for the decision binding. Yes, legal reasoning. Why we need a yes, legal binding. It's a legal reasoning for decision binding. That is meant by decide. So we need to look around this. Yes, and next word because. So what is this meant by? Is the other thing said persuasive? So persuasive approach, we need to look around. Sometimes we have a case law, but we need to look around the current situation and the current facts and figures within the case. Any question there in between two? Anyone, please? Between these two terms, we are okay? Okay, then like here, set the ratios of consent for bodily harms. So like we need to be concerned, yes, between if anything, so we need a consent there. And the reason behind why somebody harmed to others. Is there any reason behind in the case? Or why this happened is due to the mental health issues, because that's a quite huge at the moment, is a huge discussion going around on the mental health. Okay, what about next? Other related facts.
You could wait, Mom. I'm on the phone anyway.
Oh, you're on the phone. Okay, that's fine. Next. So other related acts. Yeah, so we need to look around these. So that's the two terminologies. Anybody any question? Okay, and judicial precedent is mean the previous case. Yes, we can use it as a, and stay decisis is the court hierarchy. They can different court can, so every court, above court like Supreme Court order, all other courts should obey them. Yes. So law reports we can use some case laws, we can use the judgment, and judicial, those can be as a judicial precedent, mean the previous cases. So how the Supreme Court can avoid its own past? What do you think? Can Supreme Court can avoid its own past precedent? Anybody any thought? Supreme Court is bound by its own the past decisions, yes? Because they don't have any above court than Supreme Court, yes? This is the highest court of land within a country. So we need to look around this.
Yeah.
Unless the practice statement, we can look around applies. It's a case laws back in 1966, allow the Supreme Court to depart if it's appear right to do so. So sometime Supreme Court can change things as well. So there are some case laws from previous cases. Judicial precedent, which is mean the past cases. So how the court appeals can be avoid its own past decision. So sometimes the facts and figures, because always we looking one thing is a clear wider interest of public. So this which will go through all today lessons. So we have, this is a little maps, yes, which is quite good to be all the key terms. So I copied the link for you to go through to memorize the thing, because sometimes we're not in purely law profession, is difficult, so we need to be go through. Okay, this word stay decisis is being derived from the stand. This is a Latin term which means to stand by things decided. So stand by things decided, it stay the same, whatever decided. The principle, the court should follow the precedent established by the previously decided cases with a similar fact and the issue to provide the certainty and consistency in the administration of the justice. Administration of the justice based on the case laws, yes? What that happened? What was the findings? Binding. So we can look around the binding precedent. It's meant by the court must abide by in its of the case. So for example, lower court is bound by the decision of the higher court, the same jurisdiction, and even the lower court judge disagree with the reasons of the outcome of their decision. So persuasive is precedent is meant by the court are but not required to rely on the deciding the case. Example, they can look around the decision from the court in the neighboring jurisdiction and then the decision by the higher court. Every court have their own jurisdictions, their own limits. Okay, any question there, anyone? Okay, next terminology. This also word is derived from the Latin terms, which is mean.
Also, basically, that's what they call in lamination now.
Okay, rational for decision. So rational, the ratio meant by the rational decision. So you need to look around the principle of the law of which the decision is based. Decision is based on what? What is meant by decision making? Anyone in? What is decision making in normal life here? Decision making. Do you make any decision? Have you made any decision from morning till now? With respect, yes? Just think about. Some we do rational, some we do irrational, yes? Always decision making is means selecting the best course of action. Best course of action. So you're looking in terms of cost, in terms of benefits, yes? In terms of performance, yes? Quality. So always we're looking all these. And so here in the laws, we look the wider interest of public. That's the key thing. Huh? And we can change the things. Huh? But is a rational decision based on the factual. Huh? Rational with the reality. The fact which have been proved the evidence. He applied the law of those facts and arrive at the decision which give the reason ratios. Yes? Anybody any question? Okay, then how to find this reason or the factual? Look at your subject outline and reading the list of the case list. Yes? So you look the case list, case laws. Yes? Take a peek at the topic heading. Look the heading. Look the case and the journal article listed in the above, below the case and read. Doing before you start reading the case will help to provide some context. So you look what was the title of the case to between, yes, and then maybe it's good to be, maybe if you want to be quickly to read, because sometimes the cases is so long and so lengthy, so it's good to be go through the decision and the outcome of the case. That will help you to be look around the interest of the, well, instead of you can't, if you can't read it full. Huh? Any question there? So when start reading the judgment, begin with the head note, and this will be highlighted the key issues of the legal principle considered by the case. Okay. So we can focus on the ratios normally appear towards the end of the judgment. But unfortunate, you can't just skip to the end. Sometimes we need to look around the in between the factually. To whom between that was, what was the case, what was the evidence produced, and is it the decision was the rational? If somebody giving you all the evidence, yes, because sometimes some people think lies blind sometimes because the lie is always based on the information, because sometimes maybe the factual information not a real, but of course judge is relying on the factual, yes. So test it, yes, use the judgment, but of course the court need to be rational behind why we want to give this decision, this judgment. In the most basic format, judgment start by the outlining the fact of the case before considering the legal argument present to the court and then making the decision. The court analysis of the legal argument is also essential reading, although the ratios will be probably be located at the end of the legal analysis. And just before the court make its finding, the defendant is a guilty or defendant was the negligent. The focus is the key fact and the argument. Your attention on the precedents or the legal principle of the court. Discuss the length, discuss the facts of the case, the judge emphasis. Anybody any question? The moment the ratio is essential is the reasoning why the court is reached at the particular decision. So that will help the rationale behind why court reached at that decision. What was why the court said to the parliament there should be a vote in terms of the Brexit. Yes, because the people, the parliament represent the people. People select their representative. Yes, so there was. It's not just the prime minister just sign it. Yes, without taking the vote in the house upper and lower whatever. Yes, which is happened. So we need to be. That's why all the elections happen in the past. If you read something that make you think you may be partly is to going to win or lose. Yes, so look around the ratio territory. Yes, we need to look around. Is there high court decision where some judge have written a separate opinion? So we can look around. The ratio won't be in judgment. Instead, look for the ratios in the majority decision. So maybe one decision was totally different judge views and then most of the decisions. Yes. So most of the decision we can look around as well. Most of the cases. The view, the key legal principle. So we can look around the sort of the ratios if there were the small difference opinion. Yeah? What is meant by ratios itself? Anybody knows? We know the ratios. Have you learned ratios? What is meant by ratios to you? Anyone? A couple of you heard about financial ratios? We know the percentage. Yes, how to calculate? Of course. So ratio is sort of relationship between two things. Yes. So you have two views. What is the ratios of? You're going this way or that way, okay, sir? So always look these and is based on the ratios is go to find this. Don't panic if you can't find the ratios. You can't find the ratio. Look at the case up in your textbook and the case lectures. Of course, we can look around all different and then we can find some ratios between. We will go through some case laws in the next lesson. Huh? Okay. Next is obiter. This refers to the judge comments or the observation. So this term itself is the judge comments and the observation in passing on the matter arising in the case before him which does not require a decision. The written remarks are not essential for the decision, but don't create the binding. It's not a binding, yes? It can be general comment, but not in giving the binding. The binding is mean that can be used for the future cases. Remark of the senior judge, for example, may be indirectly instructive or persuasive, especially in the area in which the law is developing. Maybe somebody says the law is a weak here, yes? Law is not really, we need to, because it's never, we have, the argument is not become, you can, but there can be other matters we can look around. In reaching the decision in the court, sometime quote the passages the found in the text of the opinion from the prior cases, yes, without acknowledging the court passage status. So we can, as in this case, we can refer those back and quote the passage of, maybe become a part of holding or the ruling the subsequent case, depending on the what letter should actually decide and how the court treat the principle embedded in the quoted passage. Because passage is, I'm looking interpretation in term of my case, in my benefit, but in the law, what is there? Okay. Anybody, any question? Next, we're looking 4.2, differentiate between the two, reversing, binding, overruling, and giving the example of how they been used in the specific cases. Overruling, binding, overruled. Yes. So what is, we can look around this method, how we can differentiate differences between. They can be used the judge to avoid following the past decision which would have otherwise have to follow. It means the judge find the material fact of the case is decided or the significant different from him to draw the distinctions between the present case and the previous precedent. So we can look around the in the current case and the previous case. So this is Balfour and 1919, and this is the new case, yes, in 1971. So these are the two case laws, yes, where the judge looked the previous and looked the current one. So reversing, this is where the court higher up the hierarchy overturn the decision. Lower court and appeal and the same case. So like you win the case, but maybe Home Affairs or the HMRC or various other cases can go to the upper court. They can take this matter to the upper court. The Court of Appeal may be disagree with the legal ruling of a high court and come to the different views about the laws and the situation of the reverse the decision made by the high court. Any question? Okay, next is the binding. So binding is a precedent is decided the case which is the court must follow by law. They have to follow, yes. So the case is only binding if the legal principle involved in the same or the fact that case are the same. A later court can increment and the inconvenient precedent which would be otherwise be a binding. We can look around the other fact on the fact and the legal principle involved. So legal principle we need to look around. So what are those can be? So material fact of the case. So we need to look around the material, yes. We can look around the hierarchy of the court, which court give the order. And we can look around the ratios, yes, as we discussed earlier. So these on the basis of these are. So 3 point material fact of the case, hierarchy of the court, which said, and how much is the percentage wise, yes. Is the rational wise, how much is the factual. Our ruling is where the court in the later case stated that the legal rule decided in the earlier case is wrong. That was the wrong decision. Maybe some judge not look the other fact or the other angle of the case, or not look the reality at that moment what is happening. Our ruling may occur when the High Court overrule a decision made in the earlier case by the lower court. Example, Supreme Court overruled the decision of the Court of Appeal, and when the House of Lords uses a power under the practice statement to overrule the past decision of its own. So these are the two cases where been overruled earlier decisions. Okay, binding. So we discussed binding. So next we're looking now overruling. We discussed. Next we have a 4.3. Describe how the court are bound by each with the reference to the Young and versus Bristol, and these are the case laws. So we can look around. Young and Bristol was the English court case established in the Court of Appeal is bound to be follow its own decision, and those two courts of the coordinate jurisdiction, except in the following cases. The court is entitled and bound to decide which two previous conflicting decisions of its own it will follow. The court is bound to refuse to follow a decision of its own which cannot stand with the decision of the House of Lords. So the court not bound to follow the decision of its own decision was given for, because that's the past, and sued the rules of having secondary effect on the legal effect on the affected decision, and not brought the attention the earlier court. Okay, that's the key was in this case. Anybody any question, please? Okay.
Can I ask you a question, please?
Yes, sure.
Is there really any difference between reversing and overruling?
No, reversing mean, you giving whatever the decision was, you reverse it, positive and negative effect, Yes?
Okay.
Overrule mean you can, whatever the decision was decided, the new section being included, yes? Based on the new laws. Old can be overruled, yes? Amendment we can say, yes?
All right.
Okay. Yes, anyone? Are we all okay? Okay, next now we're looking the judicata is meant by, which will go through the impact. What impact can be? A decision pronounced by the judicial tribunal having a jurisdiction over the cause and the parties that disposed of once for all the matters so decide, except on the appeal it cannot be relitigated between the parties or their previous. So we can look around this. What is this meant by definition? Yes, the decision is about the decision pronounced by the judicial tribunal. Yes, having a jurisdiction. So this is about jurisdiction. The word read. Yes, Hita is mean jurisdiction. So if we look here, the thrust of the doctrine, which is to prevent the party from litigating an issues or defense which already been determined. So which is already been determined. So some cases can be reopened, yes? Some can't. Is a significant evidence now we can be reopen the case. Maybe you heard about some child abuse cases, yes? So the known as a cause of action or issue which could have previously been litigated. The later principle being established in the case of this is the case law, and ensured as the matter of important public policy. So especially in the child abuse and various other cases, public policy, yes. Of the judgment, so prevent of the waste of the judiciary resources on the repeat hearing of the same issue. So there is we need to look around how significant is it welfare of the society in the wider interest. Is it need to be amended or not? Huh? Anybody any question? Okay. Then this is the case about the Virgin Atlantic Airways. And then other parties, and that was the case 6 principle. A party is prevent from the bringing the subsequent proceeding to challenge an outcome that already been decided. The cause action. If the claimant succeed in the first action and does not appeal the outcome, he may not bring the subsequent action on the same case of action. They recover the further damages, which we discussed last previous lesson. Doctrine of the merger treat as the cause of action as having been once the judgment have been provided, and accordingly the claimant only right is the judgment itself. So next condition can be a party may not bring the subsequent proceeding on the issue that already been determined. The fifth one can be a party may not bring the subsequent proceeding which should or could have been dealt in the earlier proceedings. And there is a general procedural rule against the successive proceeding. Yes, so we need to be look around those as well. So these steps can be, and the principle can be followed, and these were followed in this case. Okay, next we have up to the pass criteria. Next we have a merit criteria now. So reversing, binding, and overruling. So overruling is the procedure where the court higher up in the hierarchy set aside the legal ruling established in the previous cases. Yeah? It is strained that within the system of state, decisive president gain increased authority with the passage of time. Yes, the previous cases. And the consequence, the courts tend to be reluctant to be overruled the long-standing authorities, and even though they may no longer be accurate reflect of the contemporary. Do we know the word contemporary? What is meant by? Maybe we heard about contemporary environment, contemporary marketing. Yes, it's all about recent issues. Yes, contemporary. Yes, the practices and the moral and the while old principles are not usually good in computer science and various other, because the things are changed. Yes, the degree of information, what was that time, what is now. Yes, because we have now a lot of we can criminal courts. Yes, we have different technology, we can use it to identify who was the criminal actually. Is it really? Yes, ruling can be operate actively with the effect of their principal laws, and being overruled is held never by to having been laws. It may even lead to the imposition of the criminal liability. Previous laws, lawful behavior, and it has not been emphasized. However, the court will not shrink from overruling authorities where they see them as no longer represent the appropriate the statement of law. So can be overruled, yes, some rule. So this is the R versus R in 1992 is the case law to recognize the possibility of rape within the marriage may be seen as an example of this. Yes, so this is the case law in being went to the court, and even here the House of Lords felt constrained to the state that they were not actually altering the law, but they were merely removing the misconception as to the true meaning and the effect of the law. And as this suggested, the court may really ready to challenge the law-making rights of Parliament in the open ways. So example, this reluctant can be seen in the House of Lords decision versus Curry versus Director of the Public Prosecution this used the presumption that the children between age 10 to 14 who were charged with the criminal offences did not know that what they did was seriously wrong, and the prosecution has provided the evidence to rebut the pre-exemption, and the pre can be known as the doctrine. So previous, yes. So meaning incapable of wrong. So in the appeal involving the two young boys who been convicted, the criminal involving motorbike, justice in this justified the reversing the pre-exemption by claiming that although it had been often assumed by the law, it had never been actually been specifically considered by the earlier. So they can see here now the difference. Yes, it's been prosecution, and then of course they're looking the age and the other things. So pre-exemption duly incapable was abolished in England in this section of the Crime and Disorder Act in 1998. Prior to that, the child age over 10 but under 14 to be convicted the criminal offence in the England and Wales. So we can look around has rebut the pre-exemption of this law or this section. This meant by they must be proved beyond the reasonable doubt. Beyond the reason. What is the beyond the reasonable doubt? Or we learn about the bundle of evidence. Yes, is a criminal matter. Yes, but not in the civil matters. Yes, because if you're charging somebody, you need clear evidence. Yes, not only the child did act the question, but they knew what they were doing was seriously wrong, rather than just nasty. So we just need to be with the pre-exemption. The prosecution had to show that the young person knew the act in the question was seriously wrong since 1998 and no longer to be proved this. So these are the reason and the felt and the just departing from the previous decision of the Court of Appeals. So this is being done is a case law, and which we can use. Our ruling should not be confused with the reversing. So which is mean procedures by which
Guess what? He's got a van. He's got a van.
the reverse decision in the lower court in the same case. Yeah?
Me when I said he got a van.
That is a different.
He has got a
Okay,
van.
anybody any
No,
questions?
you can't lie. So if you need anything.
Sorry, I don't have this in my. Hello.
Anyway,
Yes.
I
don't. Can you hear me?
Yes, I can hear you. Someone I need to.
Right. I don't seem to have this in my module. Is there a way I can get this part?
Yes, I can send you via email, and plus, I can ask Roman to upload all the latest slides, because I'm adding more things, because I'm adding some minor things to clear the.
If you can ask Roman to upload every update on Moodle, that would be awesome.
No problem. I will definitely, and I'll send you as well copy. I have your email.
All right.
Okay, we'll do this little quiz. Yes, this is all about. So just a basic understanding quiz. So you just can copy the link if you want, and we can look around this. Can you see my screen? Yes. So we start. So first one, which of the following does not give the free advice in the civil cases? This is a general knowledge more than the specific to, but that also is a law. What do you think? Which one? Free advice in the civil cases, yes? Which one?
Maybe A.
We'll say maybe A. Okay. Okay, we'll go through. What about next? Which area of the law is use the most public funding? Is it a criminal, tort law, human rights, or family laws? The legal aid, yes? Sorry, which one?
D,
family laws, yes? That was criminal law, yes?
It's
Okay,
a crooked
next,
criminal.
yes, criminal use more, because to prove it, they need bundle of evidence, yeah? Okay, what happen if you win the case using the conditional fees agreement? This is our daily life, we have a lot of company, no win, no fees, yes? What do you think? You win the case, yes, no win, no fees. What they will charge you then?
Pay nothing.
Pay nothing or pay, yes? Or pay normal fees and success fees? Or pay success fees or pay normal fees? Which one you think?
Oh, to win a case, isn't the condition? Oh, okay, sorry.
So we won the case, huh? No win, no fees, but we won the case.
Pay the normal fees. Pay the normal fees and success fee.
You pay the normal fees, you pay the excess fees, or you pay just, or you pay nothing.
Pay this success fee.
Because there is a conditional fees was, yes, decided, like various cases, the injury claims and things. So which one we
Pay
think?
the success.
You want one, A, B, C, or D?
Pay the success fee. C.
So we'll go C. It should be B, yes. You pay the normal fees plus excess fees, yes.
Okay.
So because it's a solicitor firm, they can earn more money, yes. Okay, what about next, please? What's happen if you lose the case using the conditional fees, yes?
A, maybe A.
You lose the case now, just think, yes? And the condition was no win, no fees, yes?
Yeah, they have to pay nothing, yeah.
You have to pay nothing, huh? Which is correct, well done. Okay, next, who received the deputy solicitor at the police station when arrested, yes? Only those are under 18, only those are that work, only those are on benefit, everyone.
Everyone?
Yes, well done, is everyone, yes? Because they're supposed to be provided. Okay, what is the cutoff point receiving funding in the criminal matters? Yes, is there any limit?
No idea. No idea.
20,000?
Sorry, 50,000?
20.
Oh, sorry, I take the wrong then. Okay, you said, but it should be 37,500. Huh? So just more general knowledge we can say. Huh? So which one of the following cases will not receive the funding now? Mental health, personal injury, family, domestic violence, or asylum. In the past, legal aid was available every case almost. Huh? Is it family, domestic violence, or is it personal injury, or is it mental health, or asylum? Which one do you think?
Maybe asylum?
Okay.
Oh,
Personal injury, yes.
okay.
If you're injured, yes, that's not, the yes. You challenge in the court. You have to. That's why, when you buy the car insurance, legal cover, huh?
Okay.
Okay. What is the disposable income? What this term? Courts check, what is your disposable income to claim your public is called legal aid. Huh?
So it's A, money left after bills.
Yes, should be right. Well done. Okay, next now, which of these is not type of funding?
It's fraud.
Fraud. Okay, yes.
Mhm.
Which act of parliament changed funding in England and Wales? Yes. Is a Sentence Act, Access Act, Legal Aid Act? A, B, C, D. Which one we think?
D.
Legal aid, yes. Sentencing and Punishment of Offender Act, yes. Act of Parliament change, yes. So we can, yes, we have a bit, yes. So 50% we got, yes. Anybody, any question? Okay, so today lesson we learn about some further key term, our ruling, and yes, bindings, ratios. So that's all was today lesson. In the next lesson we'll go through assignment brief, and we look assignment brief, how we can address our learning outcome. That all will be focused in the next lesson, assignment brief. Any question? If you have any question, please drop me email on my email address, anjum@ukversity.co.uk, and I'll get back to you. Please carry on. You can follow the good website Tutor to You. I can send you some books as well if you want, and this slide I'll request Raman to upload. I can send you via email as well.
Okay.
So that's all today. Anybody any question before finish? No question?
No.
Okay, so we'll keep up to here.
All right.
Okay, thanks for attending, guys. If you have any question, drop me email, and hope so I'll speak to you all during next lesson.